Okay. Good morning. I'm sorry to be getting started late. We have our quorum and we're going to get started. My name is Shoshana Bule. I'm the director. And with me are members of my staff. I have Kristen O'Neill, Kristen Smith, and Miguel Carlo Bautista. We're going to go around the table and take the roll here in Albany, and then we'll take the roll in New York City. We don't have anyone yet joining us from Buffalo. So let's start.
Ian McCallum, I'm with OGS.
Great.
Amanda DeSantis, Office of Lieutenant Governor.
Stephen Waters, retired owner and publisher of the Rome Sentinel.
Anais Vasquez, Department of State.
Peter Grimm, representative from the governor's office.
Jay
What are you
Spilsborough, an attorney, and committee member.
Thank you very much. We have a special guest this morning who is looking to speak to the committee, and we're going to do it out of order because he has another pressing engagement that he has to leave for shortly. So we're going to make him appear at some point and hear his presentation, and then we'll get on with other committee business thereafter. Excellent. We are welcoming Assemblymember Chris Burdick and potentially members of his staff with him.
Well, good morning. I hope that you can hear me okay. Is everybody able to hear me? Thumbs up?
Yep,
if you
I
can.
can hear you.
Super. I first want to tell you that as Shoshana had mentioned, I'm a member of the New York State Assembly. I represent the 93rd Assembly District in Westchester County. And I want to thank Shoshana for inviting me to your meeting. And I also want to thank each of you for the work that you do as members of the Committee on Open Government to help promote transparency, accountability, and open government. And I want to make it clear that whatever tweaks and amendments that I would propose to FOIL is completely in alignment with the basic structure of FOIL and with its need to continue to provide that transparency and openness. My perspective on this does come in large part to some 20 years in local government, 7 of which was as a full-time supervisor of the town of Bedford in Westchester County. And I always felt that a lot of what we could do could be avoided by simply putting on our website documents that may be requested from time to time, and that I felt the public had the right to see and be able to examine and ask questions about. As examples, it would be contracts with our collective bargaining units. It would be greater detail with respect to the town's budget. And I do think that it reduced the need for individuals to even have to avail themselves of FOIL in order to get these documents. You know, unfortunately, that's not always the case. And unfortunately, FOIL has been really converted by some bad actors for fraudulent and criminal activities. And a lot of what I would like to see is some way of trying to address that, but also to avoid unwarranted invasions into personal privacy. And I had the opportunity of discussing this with Shoshana because, as she may have mentioned, we appeared together as panelists for a New York State Bar Association symposium up in Saratoga Springs earlier this month. And, you know, we found that there were some areas of common interest. And I first want to touch upon some of the abuses and fraudulent uses of FOIL requests that we have seen and in fact have occurred. Cybersecurity concerns, phishing schemes, agencies and municipalities that are totally inundated by requests. And there also have been real efforts to weaponize FOIL by individuals who may be disgruntled with a municipality. Maybe they didn't like the decision that the planning board had. And so they decided, I'm going to get back at this municipality by just flooding them with requests that had no valid purpose. And so we have many instances in which there are significant personnel resources that have to be devoted to this effort. And in some instances, they're for municipalities that have one full-time employee, and that might be an individual who doubles as the town clerk, that doubles as the receiver of taxes and so forth. And it's really a problem for these municipalities to try to follow the law, but at the same time, get the rest of municipal business done. There's another concern too, and that is that individuals may avail themselves of requests by the municipality to sign up for newsletters. And that could come from the mayor's office or the supervisor's office and so forth. But it also could come from the police department that want to be able to send out alerts for hazardous conditions, say that there are power outages, or that there's an accident that has occurred and that they can that they should be aware of it, and so forth. And to the extent that people's personal privacy is being invaded because FOIL is being used in order to do a dragnet of all of the email addresses and personal information that the municipality or the police department may have obtained, then that has a chilling effect on the ability of the municipality to communicate with their residents, because it may discourage residents to say, well, I don't want my email or my personal information to be used in that manner. And so, we have seen on cybersecurity concerns some pretty sophisticated efforts in which, as an example, a mass email request, which was actually denied by FOIL, but still is on appeal. And what it is a request was brought by Freedom Foundation, is the name of the entity, and they were seeking job information and work email addresses for all New York City employees. And, it was just a huge, incredibly large request. And while the first department had affirmed denial, this is still on appeal. And so this is an example of an unduly burdensome effort on the part of the requester, but you can see that this goes on. And there also have been instances in which you have an effort to use it in a criminal manner. For example, there was an instance in which, and this occurred earlier this year, and this was for the town of Cortland, in which there was a FOIL request for all of the information pertaining to applications before the planning board. And what ensued from that is that there was a whole spate of fake permit invoices and zoning permit scams to impersonate municipal staff and to try to pressure victims, applicants before the town to pay bogus fees. And so that's an example of a criminal use of FOIL. There was one instance as well out on the island where a company that had been billing themselves, the name of the company is Smart Procure, a Florida-based company that claims on its website to have, quote, the largest government purchase database out there. And its customers include businesses that bid on government business. And so customers gain access to information through paid subscriptions and so forth. Well, there was a request that was made of the NASA BOCES, a FOIA request by Smart Procure for 5 years of purchasing records. And then they later received some phony invoices. Now, there was no smoking gun as to whether or not the cyber criminals were using Smart Procure's data to craft fake invoices. But that's an example of where it can be used for criminal purposes. Then, as Shoshana was mentioning before, there have been efforts to get personal information, and those would be emails, phone numbers, and so forth. So with that, I'd like to go forward with, I have only 3 slides, be quick about it. And the first has to do with trying to manage and trying to put some kind of constraints on the huge resources that would have to be devoted and overwhelming an agency with the request, and to try to shift the burden of costs for extraordinarily large FOIA requests. And so, and I have not written the bill yet, but the components would be to allow an agency to estimate what the charge would be and the expense that would be in pulling together the documents that are being requested, and then require a notice and cost estimate to the requester be provided to the requester before proceeding. There would be fee waivers for journalists, nonprofits, and so forth, but the objective of this is to try to put some kind of guardrails against these kind of abuses. And so that would be the purpose of that bill. If you could go to the next slide, please. So the second one is, and this would not be an amendment to FOIL itself. It would be a civil or criminal offense that, and what would be an amendment to laws there rather than the FOIL law itself. And that would be where the behavior was quite clear and very hard to refute, that there was no legitimate public interest in the particular FOIA request, and that it was being used in a way to carry out fraud or other criminal activity. And, you know, obviously there are questions that would need to be answered in terms of, you know, how do you establish the intent? How do you establish how, you know, what the abuse is? What is the threshold that would need to be met on the part of the municipality in invoking a this change in the law, and who would be enforcing it, who would have standing, and so forth. Next slide, please. Now, this is one that Shoshana, I think, was touching upon at the very beginning, and I do want to make it clear that I am really anxious to work with the Committee on Open Government on the proposals that I would have. And this is one that I had a version of it working with Eric Gordon, who is with the firm of Keene & Bean and represents the town for which I used to be the supervisor. And this would have to do with efforts in a dragnet to get home email addresses and telephone numbers and other personal information. Now, we had looked at the bill from the standpoint of adding it as an exemption, but I have no issue with having it, rather than putting it in that section of the FOIL law, rather put it in as within the definition of an unwarranted invasion of personal privacy. So I'm working with my legislative director, Catherine Fennell, in fashioning the legislation in that manner, and so that it aligns more with what Shoshana and presumably the committee would like to see how it might be structured. And so those are the three pieces of legislation that I am considering now. And the next steps would be to finish drafting it and hearing back from you folks in terms of your comments and how you feel about it, what changes you think would be appropriate, or objections that you have, or any kind of improvements that you might have in it. And so with that, I am more than happy to field any comments or questions that you might have.
Thanks so much, Chris. I appreciate that. Just for reference, maybe the proposed legislation number 3 does appear as a proposal in our draft report, which has been circulated for purposes of this meeting and publicly posted. We have selected, at least my proposal is that to put to the members that we select the second of the 2 bullet points that you've identified here as possible ways to approach this by including it in the definition. The challenge with an exemption is that it potentially can be lost in the sauce, but by defining this type of information as unwarranted invasion of personal privacy as a matter of law, I think takes us a little farther for the entities that wish to apply this as exempt under 87(2)(b), unwarranted invasion of personal privacy. If it's definitionally exempt, it helps to create more of a fundament for that. So that's the approach that I'm proposing that the committee consider for purposes of inclusion in our annual report this year. If Kristen, if you want to flip back to the other proposals, and then we can open it up for more general talking. Legislation number 2, just going backwards. This, you identified in the considerations section sort of the money questions. Very difficult for a group of us transparency folks to weigh in so much on those considerations. We definitely, as the director and staff that are assigned to discharge the Secretary of State's function as the secretariat to the committee, feel that we see people complaining about the targeted behavior. We definitely hear those complaints. We definitely feel the frustration and anger and just sense of helplessness that many communities feel, especially those ones that you identify have very few staff, 1 or 2 members of a staff in a village or town dealing with this is very, very frustrating. Creating a cause of action under some other statute to separately address these kinds of things, may be a good solution. Certainly difficult for the committee to propose it since it wouldn't necessarily be an amendment to the FOIL, but would be happy to discuss the impact in its report of both the positive and the potential negative of the considerations, not really knowing how to define those without court intervention in a report. So once you get a proposal together, I'm sure this committee would be very interested in providing feedback. I certainly would, to understand more about how we would go about creating a civil or criminal path forward for these entities that are struggling with this targeted behavior. And with respect to legislation 1, this is where I feel like in New York we have the strongest, the tallest bar. We have a very strong history in New York of cases and courts sort of finding that it doesn't matter, how big your request is, as long as it enables an entity to reasonably understand what it is and find the records that are responsive to it. It'd be very difficult to identify the correct sliding scale for how to identify whether it's 1,000 pages and 10 staff hours or 10,000 pages and 100 staff hours, depending on the type of municipality. There already is a provision to require notice and a cost estimate in FOIL. Fee waivers are already permitted. And as far as limitation on total charges or justification, that's where the very difficult part would, I think, come into play. In the same way that in our proposed report, our draft report this year, we talk about how it's very difficult and have historically spoken about how difficult it is to support legislation that would create a sliding scale or create a different fee depending on the size of a municipality, or a different number of days permitted to respond depending on the size of the municipality. I think we have the same challenge and struggle supporting legislation with the current way the courts have interpreted FOIL. So that's my personal, like my feedback based on our historical conversation as a committee, our historical reports, and what we've said so far this year. But I open it up to any member of the committee or staff to talk further about 1, 2, or 3, and how we might view these things as we get proposals from you on them. So I open it up. Anyone else wants to say a word?
Regarding legislation proposal number 1, I can't see a justification for including nonprofits. And I'd have to have that explained to me. I can understand from a journalist's point of view, being a journalist, but I'm not sure, other than experts, not-for-profits should be included. With number 2, I think it would be very difficult to establish intent. Therefore, it would seem to me that we have to resort to evidence rather than intent. Those are my questions.
So, one question that I might have, and Shoshana, you, I think, may have some familiarity with this, is whether we might be able to get some guidance from any judicial decisions that have upheld what a municipality might do in denying a request or something to that effect, and whether any of that might be codified in an amendment to FOIL.
So there have been very few that I have been able to find, situations, cases reported or otherwise, in which a court has reacted and issued an order in response to harassing use of FOIL. There are maybe 3 or 4 that I can think of that we commonly are able to provide to municipalities when they have very factual situations that may rise to the level of this kind of malicious use. What the problem is that codifying that will be almost impossible because they're very fact-specific inquiries.
Mhm.
So each case that we have found turns so very specifically on the facts of the situation that have been brought to the court that I feel like codifying that would be very difficult, which is probably why it hasn't already been done.
Mhm.
Even in other states, I think it would be very where the FOIL burden, where the FOIL population is so much smaller. In New York, we have tens of thousands of FOIL responsible entities getting potentially hundreds of thousands of FOILs a year. That that universe is unknown. But in a smaller state, Rhode Island, say, you may be able to try to figure out the spectrum of factual scenarios and maybe legislate around it. But I think in New York, we would struggle.
Well, that's helpful to know.
No offense to Rhode Island.
No. Well, great. If there are any other questions or comments, I would certainly welcome them. Any suggestions that you might have on any of this? And Shoshana, as you were suggesting, we will put this together in actual proposed legislation and get that over to you so that you might share with the members of the committee for comment.
Sure. And to the extent that the committee takes me up on my draft proposal, proposed legislation number 3, that in your slide number 3, we'd be happy to work with you as a sponsor of that legislation. moving forward. That would, obviously give it a stamp of at least one approval that we would be happy to put forward and share.
If I could add one more question or observation, it doesn't apply to any specific one of those, but the proposed legislation. It's very, very difficult to identify potential criminal activity before the act itself. And to try to legislate to do that would seem almost impossible. However, if one were to create false invoices based on that kind of information, after the fact, you could add to a penalty so that it wouldn't be a priori, but it'd be ex post facto, and maybe a better deterrent if applied afterwards.
I think you're right. I mean, it seems as though the idea is deterrence. The idea is to, and hopefully it's made known to bad actors, right? And that I think it makes a lot of sense for it to be an additional penalty to dissuade and discourage these attempts.
Thanks so much for joining us. Unless you have more
Absolutely.
to-
Well, thank you so much for inviting me. And again, thank you for the work that all of you do. And we'll be getting over some proposed amendments, and Shoshana, I would be happy to carry the bill that's legislative proposal 3 along the lines that you are suggesting to the committee, it being an unwarranted invasion of personal privacy.
Thank you so much. I appreciate you. I know you have another place that you have to dash off to, so we're trying to respect your time. Sorry we were late getting started. And we look forward to getting more information from you as the season rolls on.
Great. Well, thank you all. Take care. Bye-bye.
Thank you. Bye. All right, so we can take any amount of time to further discuss these things if you want to discuss them now, or we can just move on with our agenda. And we will move on, if we can, to the approval of the minutes or the vote on. And so if I could direct your attention to the draft minutes that were circulated and posted from our last meeting of last season. If you would like to, if anyone would like to make a motion to approve the minutes, thank you, Stephen. Do we have a second?
I'll second.
Great, thanks, Amanda. If anyone has any objection to the approval of these minutes as written, please state it. Hearing none, the minutes of the November 20th, 2024 meeting are approved, and we will post them in final and circulate them for everybody. Okay. I'm going to give you a brief stats update. These things, they'll be more finalized in as the report gets done. But as far as phone calls between last, I guess, November through this August, 1,260 approximately phone calls that we've substantively dealing with members of the public and the press and the government. Informal and formal advisory opinions. This is a big number, 3,317 on the uptick, on the rise. Our appeal log references 5,640 appeals properly sent to us by agencies with the resolutions from those agencies pursuant to that statutory requirement that they do so. We still believe that we are not necessarily receiving all of those. I know that in our training, we make every effort to remind municipalities and FOIL responsible entities that they should be sending us their FOIL, all their FOIL appeals and their responses there too. But I almost positive we're not getting everything. Sometimes we get a reminder of that when a FOIL requester will write to us and say, hey, did you get this my appeal from entity X to entity X, and we say, no, we did not. So we know that then we can reach out to that entity potentially and say, hey, this is your responsibility, please, in the future, send us this and send us anything you got. And sometimes that, results in a flood of, oh yeah, here they are. So as soon as, again, the penalty for this, I think, ultimately would be take training. So, that's not got a lot of teeth. Live and virtual presentations, 27 since we last met, about 1,000 participants live and virtual. And FOIL requests. The state entities have gone to a platform called GovQA. So a FOIL requester can request documents through this FOIL portal. We had OpenFOIL for a while, now we have GovQA. This allows a FOIL requester to click a button to submit a FOIL request to an agency or agencies. We have seen a significant uptick in FOIL activity in the wake of these online FOIL portals, because FOIL requesters will not only seek their records from state agency A, but then they will also add us, even though we don't maintain the records. So we have a lot of responsibility to basically refer people back to agencies where the records are maintained. So I would say if we were counting those FOIL requests as those that we received, they would be in the thousands. But we are seeing for our own records here at the committee an uptick of requests as well. We've had 74 in the period since we last met, which is a serious uptick because we don't really maintain many records.
So if I could ask a question, when we get the request, do we pass it on to the agency and to go to the caller and say, go to the agency, so they get two opportunities to be sure that the agency knows?
Yes, yes. In fact, on GovQA, there is a big pop-up that comes up every time somebody selects to get records from us that says, be advised, we are not the custodian of the state's records. If you want records of an agency, you should ask the agency. We don't have them. And it's like in bold.
Yeah.
People click right through that. But so there is a mechanism for us saying, we're not the right one. Here's the right one.
I'd like to get that for ODS as well.
Yeah, sure.
We,
I
I
worked
don't know if
with-
we can, but we get a number
Oh,
of
they have-
requests that are not related to.
We have
what do
we
all.
worked with the WebEx staff when we first, not WebEx, the GovQA staff when
They first were
starting this. And they had great suggestions for creating detours and basically, different way. For example, if someone starts typing certain words, they also get a pop-up saying, hey, we're probably not the right person.
Wow.
It doesn't matter, we're still getting hundreds and hundreds of requests. But like, there's the big warning, if people start typing, for example, the word, pretty records or incident report, which are the types of common things that we're getting FOIL requests that are not ours. A pop-up occurs on their screen saying, hey, just so you know, you probably don't want to be submitting this to get open government. It doesn't matter. They can't.
Body worn camera.
Yeah.
But anyway, if you'd like to work with, they were really wonderful to work with in
Great.
terms of creating these attempts to divert
Redirect people.
Redirect
Yeah.
people.
So that was our brief update of statistics and things. And now I would like to invite us to look through and give and react to the draft of the annual report that I submitted around. Offer any additions, deletions, comments, changes, so we can turn around another draft and for our next meeting. And we can go through it piece by piece like we normally do toward the end of the cycle, or I think first if we should maybe just open it up to anyone have any kind of specific reactions. Because I don't know if we're ready to do a line edit yet.
I thought it was very tight and to the point and focused and well done.
Thank you. How does everyone feel about the new legislation that we proposed? That's sort of, much of the rest of the report is sort of a discussion and reaction to stuff that's otherwise going on, and some of it's themes that we've had in prior years and some new stuff, but how about, there are a couple of things that we did maybe in letter J, which is starting on page 10, and then Roman numeral 3, starting on page 11, that are kind of new content that we haven't discussed before.
I think it's good that we had this discussion with Chris, because the only question mark I put on there was on the factual circumstances with Colin and employee addresses. So it was a good point.
Yeah, I think, this is less of a comment on work
Yes.
information and much more a comment on the personal
Personal.
side.
Yeah.
We discussed that case, but I think we have a much higher level of resistance in general to providing a kind of personal privacy,
Yes.
imprimatur over information that's work related. Definitely the same cybersecurity concerns. But the personal stuff, I think, is fair game. As we know, historically, the committee has opined time after time that a personal email address, for example, existing on a document submitted to government, it can be redacted when in response to a FOIL request on personal privacy grounds. It's just when the court took a left turn in 2019 and said, notwithstanding these individual email addresses that may be hanging around on documents, if you have a list of personal email addresses, well, you have to disclose those. There's been a significant amount of pushback on that. And ultimately, in light of what's going on today with identity theft, phishing, and even just personal privacy, like vitriolic, uncivil use of information by just folks, it might be time to legislate around this a little tighter to prevent this loophole of these lists, because I see the potential disincentive of people engaging with their community, like Chris was saying, who wants to get on an email list to get an alert about a sewage spill or an accident in the main intersection in town, or even a movie night at the town gazebo, if they're going to get phishing attacks because these email lists are up for grabs. And so I was just rolling into Roman numeral 3 there on page 11. We just made a comment. We've seen an uptick in entities making use of third-party services to get information that is, generally nobody would dispute should be immediately available under FOIL or otherwise, sort of this proactive disclosure type material, titles, deeds, these kinds of things that are filed in counties and towns. But we've seen some resistance by towns to completing FOIL requests when they have these third-party services operating. We thought it was worth a comment to say, look, it's perfectly valid to use a pay service or a subscription service so that a real estate agent can easily get access in a day to a deed for $1 a page. But you still have to respond to a FOIL request by someone for a deed for $0 if you maintain it as a PDF, So in light of those concerns, that's what was the genesis of this little section of the report, that sort of as a comment. We haven't historically made so many of those, but in light of what's happening, we felt like it was worth a comment. Well, we can leave the rest of the report to be digested. I know you only had a week to look at this so far. And, the main meat of the discussion in the report as far as reacting to pending legislation had to do with the very large FOIL bill that's sort of a renovation style bill that had a lot of components. We dealt separately with them because historically we had sort of said, we don't support this gigantic behemoth of a thing because of, the various ambiguities that it may inject. But we thought this year it was worth more of a parsed look because these proposals do recur. They are associated in my view as a former employee of a state agency responsible for FOIL responses and other as a general counsel with a significant fiscal impact potentially. So I thought it was worth discussing how these pieces both may conflict with existing FOIL philosophy and be a departure from that in many ways, and also have a big cost imposed on not just big state agencies, but agencies with one employee. So it was worth a thought about how, never mind the COOG, which itself doesn't have a huge staff, but would be required to have quite a big staff if some of these proposals were put into motion, deciding appeals, being an adjudicator for for complaints and other kinds of things that may go on, mediation programs, all these things not contemplated in anyone's current fiscal thinking. So that's the reason for the more beefy discussion this year. All right, should we move on to see if anyone who is joining us on the WebEx has a comment?
Certainly. Open up my screen larger. Just take me a second. I'm going to stop sharing this because I think that's making it a little hard for me to see. All right, right now we have, if anyone else, I see one person has identified themselves as somebody who would like to participate in public comment. So I'm going to unmute that person in just a moment. But if anyone else who is participating online would like to, just if you want to do the raise the hand function, and just a moment, I am unmuting. Mike, everyone just, as a heads up, everyone has 3 minutes per person for their public comment period. So, Mike, I'm inviting you to speak.
New York State real estate broker. I was this small claims assessment review hearing officer for the Unified Court System for 4 years in 6 counties. And I advocate for taxpayers so far in 39 counties. And for every client, I have to FOIL assessor data. And so I think I have a unique experience as to how FOIL works across upstate New York. And it's pretty concerning. This year, I probably submitted 40 FOILs for clients, and I didn't get a single one of them fulfilled in full. They delay me, they evade me, and like the first page of last year's annual report, Obama said the government should not keep information confidential merely because public officials might be embarrassed. Well, it's way worse than that. We have laziness, incompetence, cronyism, and outright fraud going on. And so when I ask for data, they don't want to give it to me because it will embarrass them, because I'll demonstrate that they didn't do their job. And so the city of Syracuse, for example, who has had 9 deputy assessors prosecuted for kickback schemes in the past 20 years, they refused to give me my FOIL data. So I and people here know the case. They just thumbed their nose at me and begged me to sue them. And I'm not a lawyer, I'm a real estate broker. So I had to figure out how the court system works to sue them. So it took me a year, $430 in filing fees, only to get data that is no longer of any use to me, because the hearing I was going to use it for was the previous September. And so, or I could hire an attorney and spend 5, 10, 20 grand on an attorney just to get data that I'm entitled to by law. It would take them a matter of 3 minutes to run the report, but they evade me routinely all across this state. And they do it because there's no teeth to this law, and they know they can get away with it. So they just evade you. And so the court, even though I clearly won, it was so obvious, didn't even return my court costs, didn't give me anything for my time, gave me nothing. So it cost me $430 and a year of my time to get a report that took 3 minutes to do, that I'm entitled to by law. And so there's just something wrong with New York State FOIL. It has no teeth, and something needs to be done. These municipalities treat the taxpayers like they are the enemy, and they don't realize that they work for the taxpayers. that if they think that they work for the supervisor or they work for the town board, but they don't think that they work for the taxpayer. They absolutely do work for the taxpayer. They're paying 10 grand, 15 grand, 20 grand in taxes, and the assessor can't be bothered to take 3 minutes to
Thank
run
you,
a
Mike.
report.
Your 3 minutes is up. Have a great day. All right, now we're going to invite Rachel Faust from reInvent New York. reInvent Albany, sorry. Oh,
Can you hear?
hi, Rachel.
Hi, yes, we can.
Okay, perfect. Sorry, I'm not on camera. I'm just on audio. So my name is Rachel Foss. I'm the Senior Policy Advisor at reInvent Albany. I appreciated hearing all the discussion. Just some thoughts for consideration for your annual report. I think particularly because the open meetings law will sunset on July 1st, 2026. This is going to be a big topic for the legislature next year. Previous open meetings law extensions have happened during the budget process. I think it would be valuable for the committee to provide some more affirmative feedback to the legislature about changes to the open meetings law. In particular, there's been a lot of discussion about the quorum requirements. I know your review of the different legislative proposals gets at that somewhat, but I would just propose that the committee maybe make some more affirmative guidance to the legislature and the governor's office about open meetings law given the sunset. And, regarding the FOIL proposals, I think to the extent the committee can affirmatively support legislation, it is certainly helpful to move those bills forward. Some bills that, we're pleased to see your support for, in principle, for a number of bills. For example, the FOIL reporting legislation, the commercial FOIL proposal. I think affirmative support rather than, conceptual or in principle is always helpful to move those proposals forward. So those are some suggestions I have. I think the proposal from Assemblymember Burdick and that you've drafted on the personal privacy issues with emails is really interesting. We will absolutely take a look and get back to you with our position on that. At first blush, I would think we would support it, but just want to take it back to the team and check it out. So thanks for your time. Appreciate your work here and look forward to giving you some more feedback in the coming weeks.
Thanks, Rachel.
Thank you. I just want to clarify real quickly is that the open meetings law does not sunset.
For sure.
I'm sure everyone understood that. Just the extraordinary circumstances video conferencing provision sunsets in July of 26.
Anyone else? That's it.
That is all. I'm sorry. No more handout.
Okay. Does anyone else have anything that they wish to raise in our other or new business section of our agenda?
We who live in the mid section of the state pay a 4-hour penalty in order to attend these meetings. And it's when you're desperate to get a quorum here, it really is unfortunate. So I would encourage us somehow to help the legislature understand how unfair it is to those people who are not near the seats of power.
I think that's both your point and Rachel's point, excellent points. And we probably will, I think what we should do is reintroduce and renovate our report to the legislature on how it, like the how it was going requirement that we had 2 years ago. We'll look at that material again and the discussion that we had last year in the report, looking at it again. We'll renovate that and include it for everyone to take another look at with any new feedback that we've received from people in the year. I think today's meeting is an excellent example of struggling to get a quorum. We were late beginning because we just, it's especially through the winter when people start getting sick, it's going to get harder to get a quorum. Even when people have every intention of getting to the physical location, that something extraordinary can happen. So I do think that in the past we've voiced our support for continuation of some form of virtual participation by members of public bodies. And I think that it's fair play and fair point that we bring it back in light of what might happen.
Technology has advanced and our experience has shown where we need further development.
I certainly I don't anticipate that the legislature will let that. I anticipate that the most likely outcome is that we get another year of the same. That it's on somebody's bingo card to make sure that we get another year of the same. But if we could make it better, sure, I suppose that's our responsibility to try to ensure that that happens. So we'll give that feedback that we have been giving and tune it up where we feel that there's opportunity to do that.
Thank you.
But thanks for raising that. I appreciate that. I was thinking about it as I was writing it down from when Rachel was saying it as well.
I have a question as it relates to this committee. Why is the third office in Buffalo and not in, for example, like Utica, where we also have a state office building?
Well, in fact, we have historically had one or two members who live in the Buffalo area, and I think that is why that office is chosen. We still do. We could, in fact, very likely use the state office building in Utica to create another public location, and we will look into that. And if we can make that happen before the next meeting, we will, and then you won't have to pay that to our penalty. Although coming here, we miss you. But it would create another opportunity for members of the public who live in Utica who want to join you.
Well, I think there are legitimate questions about how you assure public access. Does it have to be at a single location? Are there other opportunities at whether it's at county offices or private? The difference between a person attending and allowing the public to attend are really separate but important.
Yep, and I think that's an excellent point. And, you know, why we didn't think of that earlier when you've been raising this point for years is a question that I will have to cogitate on later.
Patiently.
But yes, I do think that there is an
I
office
think we
space.
had considered it, but then you were not going to be here in person, so we tabled it.
Okay.
That's, if we had known you're going to be here in person, I think we would have given it more.
If it was my other eye that had been operated.
Yes, I mean, we don't want you driving with compromised eyeballs, so let's do that. Let's consider that. But you know, I appreciate those. Anyone else? I'm not gonna put you on the spot, James, but this was your first meeting. You have anything that you want to add or just absorbing?
I'm just taking it all in. I was, it was very interesting, and I'm sure I'll have lots of opinions on things as I get my bearings.
Great. We appreciate it. All right, well, can I get a motion to adjourn our meeting?
This is kind of record early, isn't it?
Yes.
Not quite, but for starting late, it might be, yeah.
Can I correct?
Yes.
Why I sent you a comment on
Mhm.
page 5 on the interagency. I just want to make sure that we're not inadvertently excluding, that we would, when it says the writer or writer's personal opinion, let's say I'm sending an email to another attorney, if Jim Leary or PC's
Yeah.
opinion or recommendation on something.
Yeah, I
Are we
don't
afraid
think that,
we're not
I don't think that
excluding
that is not, I don't,
as
to
written?
me, I don't think
Right.
that's an ambiguity that's introduced, and I'd be hesitant to make
Yeah.
a comment because
Right.
I'd be afraid of triggering someone to think that it was an ambiguity to be introduced. I don't actually think that, I think that also other exemptions would apply to the
Yes.
situation that
Yes.
you're describing. But
Or a non-attorney, then maybe that would,
If you-
let's say if I write a fund, which, me to,
I think
What
that
about
it doesn't have to be the
non-attorney, right.
opinion of the writer. It has to be the
Right.
writing of the writer. And I'm not
Right,
worried.
right.
Yeah,
yeah,
But,
I mean, I
um,
would still take it, but just.
And
Overall,
the
we don't support
strictly-
that bill.
Yeah.
It's a giant bill.
Right.
It's an omnibus
Yeah,
bill.
but
so-
it just seemed like that provision, that's why.
And we're not really interested in tinkering with
Right.
the interagency exemption to begin with. I think historically we haven't been, open to suggestions, but the kind of tinkering that we've seen attempted in that regard has been along the lines of excluding people from being members of an interagency group and in a way that the consensus has always been would dampen deliberative conversations and squelch opinions before a final determination is made, which is not an outcome that's desired. But happy if you have something like that, if you have a thought that you want to, that's to
Think about, yeah.
think about as a nugget. I'm just afraid of drawing some attention where we are not we're not in support.
Understood. No, I agree.
But,
Thank you.
all right. All right. Motions to adjourn?
We'll move.
Okay, any second? Right. All right. Hearing no objections, we are adjourned at 11:07. I'll see you in October. Take care, everyone.
Thank you.
Thank you.
Thank you.